everybody, we're going over the Texas Penal Code again. I've got our Trial Bureau Chief, Luis Baez here. I'm Brian Foley with Houston Criminal Defense Attorneys. We're going to read the statute. Today's statute is 9.06, Civil Remedies Unaffected. And this is what the statute says. It's a one-sentence statute, so this might be a pretty quick episode. The fact that conduct is justified under this chapter does not abolish or impair any remedy for the conduct that is available in a civil lawsuit. Okay. I have to be honest, hadn't read that one until we got to this part of our video series. It almost never comes up in the practice of criminal law because really what this is saying is that just because you're found not guilty in a criminal case doesn't mean you couldn't be found liable in a civil case, right?
That's correct. So the classic example of something like this is O.J. Simpson in California in the 90s he won the criminal trial where he was found not guilty, he was acquitted, but later in a civil lawsuit, attorneys for the estate of the victim in that case ended up winning a civil suit and got a judgment. And that's because in the criminal system, the standard is beyond a reasonable doubt, whereas in the civil system, the standard is preponderance of the evidence, which has its own descriptions if you're reading Texas case law. But the thinking is that the civil standard is lower or easier to prove than beyond a reasonable doubt.
And I'm trying to think of how this could come up in like civil remedies unaffected, right? So if you're justified under this chapter, well, typically you'd be justified if it's self-defense for like a shooting or something like that. Then in the civil case, you'd be justified anyway. So I was trying to think of an example of that. The only thing I could think of is necessity. Like if you get in a DWI wreck and you're that's negligence, right? So let's say you hurt somebody in the wreck, but you needed to do it because there was a guy chasing you with a gun and you had to drive to get away from that guy. So it's necessity, right? You're going to get killed. He's shot at you 3 times already. There's bullet holes in the back of your car. It's necessity. Even though you were drunk, you had to drive, right? So you're not, right? I mean, you think that would fly as a defense to necessity, but then you could still be held civilly liable?
I think so, again, because the standards are a little different. The other thing, too, is that when we're dealing with criminal cases, we're not often dealing with like insurance. And right. Insurance is a huge part of like civil cases and whether or not insurance covers certain acts or certain events. And so I can see something where an insurance company may say, legally, criminally, our client or our insured isn't responsible, but maybe there's a universe or a certain venue in Texas where if we get sued, we're probably going to lose anyway. So maybe let's just try and resolve the civil case somehow.
Yeah. Okay, folks, that's 9.06 of the Texas Penal Code, Civil Remedies Unaffected by Your Justification in a Criminal Case. We'll see you next time.